Imagine if a police officer pulls you over for a simple traffic stop, but then maybe engages in using deadly force, and the court said that the only thing that could be considered is the split second when the officer decided to pull the trigger. Now, consider the Supreme Court reviewing that case and issuing a 9-20 unanimous decision, rejecting that rule only for the lower court to then ignore the warning and the ruling issued by the Supreme Court and then double down anyways. Well, that's not just a hypothetical. That just happened in a critical case. And now this issue is likely heading back to the Supreme Court, even though they just issued a 9-20 unanimous ruling just 6 months ago. So, let's break down what is happening in this critical case. Now, before we jump into this video, I just want to mention that today is my birthday. I want to thank you guys so much for all the support that you guys show me and the channel. And I also just wanted to mention that if you want to give me a free birthday gift, just drop a comment down below saying happy birthday or something like that. I would really appreciate that. You know, that means a lot to me. And then also consider subscribing to the channel, because of course that also helps the channel to grow. Now, as I mentioned in the intro, in this video we're going to be discussing a recent 9-20 unanimous ruling that was issued by the Supreme Court. This case involves the Fourth Amendment's protections against unreasonable searches and seizures, and when law enforcement activities through excessive force actually impact those rights. This unanimous ruling issued by the Supreme Court came in a case called Barnes versus Felix, and this case may already be heading back to the Supreme Court for re-review in just 6 months after the Supreme Court issued that ruling. That is because the Fifth Circuit has issued a new ruling in this case, claiming to do so in light of what the Supreme Court just said in that 9-20 decision. And the Fifth Circuit has once again ruled that the officer's actions are protected even under the totality of the circumstances approach. And in fact, even the en banc panel in the Fifth Circuit has now denied review to this case. The Fifth Circuit has engaged in some very interesting reviews of this case after the Supreme Court remanded the case back to them after their new ruling. And this really just tees this case up for a re-review once again by the Supreme Court, and a really fast re-review, because again, the Supreme Court just issued their ruling in this case 6 months ago. Now, the facts surrounding this case are as follows. Essentially, Roberto Felix Jr., a law enforcement officer, I believe, in the Houston area pulled over an individual Ashton Barnes for suspected toll violations. I believe the camera there picked up some toll violations. It might have even been a rental car. And so, the rental car, I think, maybe even had toll violations. So, the individual was pulled over by the officer. The officer told Barnes to exit the vehicle, and Barnes opened the door and acted like he was going to exit the car, but then he attempted to drive away. Now reacting in a split second, the officer then decided to jump onto the ledge of the moving car. And then he also decided to pull his firearm and then shot Ashton Barnes twice, and it was a fatal wound. Now, as a result of this incident, Ashton Barnes' mother sued the officer, alleging that the officer violated Barnes' Fourth Amendment rights against excessive force. Now on review, the District Court granted summary judgment in favor of the officer applying the Fifth Circuit's moment of threat rule. The Court of Appeals ultimately on review in the Fifth Circuit affirmed that explaining that the moment of threat rule requires asking only whether an officer was in danger at the moment of the threat that resulted in his use of deadly force, and under the rule, events leading up to the shooting are not even relevant. Now, this case, like I mentioned, made its way all the way to the Supreme Court. And on review, the Supreme Court this year, I believe in May, issued a 9-20 unanimous ruling in favor of the individual Ashton Barnes. And the court held that a claim that a law enforcement officer used excessive force during a stop or arrest is analyzed under the Fourth Amendment, which requires that the force deployed be objectively reasonable from the perspective of a reasonable officer at the scene. The inquiry into the reasonableness of the police officer requires analyzing the totality of the circumstances. That analysis demands careful attention to the facts and circumstances relating to the incident. So, in this case, the Supreme Court rejected the more limited moment of threat analysis that was used by the Fifth Circuit, and instead they applied the totality of the circumstances approach. They stated that most notable here, the totality of the circumstances inquiry has no time limit. While the situation at the precise time of the shooting will often matter the most, earlier facts and circumstances may bear on how a reasonable officer would have understood and responded to later ones. Prior events may show why a reasonable officer would perceive otherwise ambiguous conduct as threatening or instead as innocuous. So the main thrust of that ruling by the Supreme Court was rejecting the more limited scope of analysis that was applied by the Fifth Circuit, which was the moment of threat review, and instead the Supreme Court ordered that the lower court, the Fifth Circuit, needed to re-review this case using the totality of the circumstances approach. Now, after the Supreme Court issued this ruling, the case was then sent back down to the Fifth Circuit for a re-review and to apply the totality of the circumstances approach. Now, interestingly, the panel in the Fifth Circuit decided to not hold oral arguments in this case or ask for additional briefs in light of what the Supreme Court just said in that new ruling. Instead, they just re-ruled on the case on their own, didn't request any of those additional briefs, and still ruled in favor of the police officer. In the new ruling, the panel held that even under the totality of the circumstances approach, the officer's actions were warranted. The panel reasoned that any vehicle flight creates a deadly threat and that Felix reasonably used lethal force to prevent a dangerous situation. Because of that, in that quick analysis and that new decision by the Fifth Circuit, without additional arguments or briefs or, oral arguments even being scheduled, Barnes's attorneys then petitioned for the Fifth Circuit on panel to re-review this case and look at what the three-judge panel just said in the Fifth Circuit. The petition argued that the new ruling by the three-judge panel in the Fifth Circuit contradicts what the Supreme Court just said in that new ruling, and even it contradicted prior decisions and statements by Judge Higginbottom, who was on the panel and who had earlier said in the concurrence that if they had to use the totality of the circumstances approach, there was no way that they could rule in favor of the police officer, but on re-review, they still ruled in favor of the officer. The petition urged for a rehearing on in the Fifth Circuit because of the new ruling effectively creates this per se rule that officers may shoot any fleeing driver, even when it involved potentially even just a minor stop or a traffic violation. The petition argues that this conflicts with Supreme Court cases and precedents and also with long-standing precedents in the Fifth Circuit about fleeing vehicles, and just fleeing a vehicle does not automatically justify deadly force by a police officer. However, the Fifth Circuit on panel just issued their order and they denied review of this case. So, in this quick notice that we got from the Fifth Circuit on panel, they stated that the petition for panel rehearing is denied as no member of the panel or judge in the regular active service has requested that the court be pulled on rehearing en banc. The petition for rehearing en banc is denied. So, despite the Supreme Court issuing that 920 unanimous ruling saying that they needed to apply the totality of the circumstances and to re-review the case, the three-judge panel in the Fifth Circuit issued a quick ruling, did not request additional briefs, did not submit for oral arguments or anything like that. They just issued a new ruling, and then when the petitioner hears tried to get on panel review in the Fifth Circuit, they quickly also rejected that. So, this is something we're going to be watching closely to see how this plays out. It's surprising that the Fifth Circuit panel decided to issue a new ruling on this case without requesting additional briefs or oral arguments in light of what the Supreme Court just said in that 920 decision. And now, even the en banc panel has denied re-review of this case despite that lower court ruling. This now tees this case up to go back to the Supreme Court in just 6 months after the court issued that 9-0 unanimous ruling in this case, and then remanded the case for the Fifth Circuit to re-review this issue. The petitioner argues that the Fifth Circuit has failed to properly apply that new ruling by the Supreme Court, and they may go to the Supreme Court once again and ask for the Supreme Court there to step in and correct what the lower courts are doing. And maybe they argue that the Fifth Circuit is just simply defying this and that they don't want to rule in a way that aligns with what the Supreme Court just said. So that is what is now happening in this critical case that was recently ruled on by the Supreme Court. And this may already be heading back to the Supreme Court for a new decision and an expansion or a new analysis based on how the Fifth Circuit has responded after that ruling. So, as we get more information, as this develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All those things help to fuel the algorithm.